Um, what we call now is durational alimony, and that will be it'll be a check for a certain duration of time. In fact, being a no-fault state, you don't have to prove anything except that the marriage is irretrievably broken. Substance abuse, domestic violence, infidelity, anything like that occurred, the courts don't need to hear about it unless relevant to another factor of the divorce.
Welcome back to Law Unpacked. Today we're talking about a topic that affects thousands of people every year: divorce. Whether you're thinking about filing, in the middle of a messy split, or just curious about how the law works here, this episode is for you. We'll clear up some major misconceptions. Like, does cheating affect who gets what? Do you really have to split everything 50-50? And how long can the entire process actually take? Let's break it all down. Joining me today is our in-house family law attorney, Josh. Thanks for being here to help us navigate the ins and outs of Florida divorce.
Glad to be here, Sean. Thanks for having me.
Let's start with the basics. What are the legal grounds for divorce in Florida?
Well, Florida is a no-fault state, so you just need to meet residency requirements so that the state has jurisdiction.
Do you have to prove that someone did something wrong?
No. In fact, being a no-fault state, you don't have to prove anything except that the marriage is irretrievably broken. Whether one party is at fault or the other, the courts don't really give much consideration to that.
So when you say Florida is a no-fault divorce state, what does that actually mean for people who are filing?
You won't need to put in the reasons for the divorce. You'll just need language in the paperwork stating that the marriage is irretrievably broken. You don't need to get into any, substance abuse, domestic violence, infidelity, anything like that occurred. The courts don't need to hear about it unless relevant to another factor of the divorce. But for just the purposes of getting divorced, the courts are unconcerned with those issues.
Well, how long does the divorce process usually take? Are we talking weeks, months, years?
Well, it won't be weeks. You'll go at least a month. You'll need the paperwork to be drafted. It'll need to be served to the other side. Even if the two of you immediately come up with a consent, draft a consent document and sign it, you would still need to go in and give final testimony to the court. So you would be looking at least a month there. Generally 6 months to a year, depending on everyone meeting all of their deadlines and the availability of court personnel. Once you're both served, you'll both have 45 days to do your financial disclosures. Once that's done, the next step would be mediation, which is required by the court prior to a trial. That can take several months to get a slot to get in. If you don't have an agreement there, going to trial, again, can be several more months before you'll get a time. If there are intermediate or temporary issues, I've seen divorces go as long as 9 years. Now, I'll say in that case, there was no attorney for either side. We were brought on and had it wrapped up within a 6-month time frame, but they can drag if you are not on top of it.
Now, you mentioned earlier about residency. What do you mean by residency? What are the requirements for filing for a divorce or residency requirements for filing for divorce in Florida?
So one of the parties will need to have been a permanent resident of the state of Florida for at least 6 months prior to filing for the dissolution action. Usually we prove that by providing a driver's license to the court with an issue date where that date is 6 months before you filed.
So under what circumstances might a simplified divorce process be available to couples?
So simplified divorces are only available in cases where the parties do not have any minor children. If there are minor children, you've got to go through the full process. If you do not have minor children, we recommend it in cases where the parties don't share any property and already have split the assets and debts.
What about annulment in Florida? Is that an option or legal separation?
Florida doesn't have a legal separation. Annulment is available under specific circumstances.
What are some of the, give me some examples of those specific
Uh,
circumstances.
so, if one party was tricked into the marriage with false claims, if there is undiagnosed or not undiagnosed, undisclosed impotency on one of the parties, if one of the parties is already married, the courts will not enforce bigotry, uh, just to name a few.
If someone is thinking about filing, so we're moving on now to the actual case application. What practical steps can they take beforehand to protect themselves legally and financially?
So we recommend knowing what rights you have and what responsibilities you'll have once the filing occurs. Once it occurs, the case should remain status quo. So if you were paying for health insurance, the court's going to order you to continue paying that. If you were paying for cell phones, the court's going to order that you continue to do so. So if you are the one who is paying a large majority of the bills, you'll want to move that to where you're splitting it prior to filing.
So, how important is it then to gather documents like bank statements, credit reports, and property deeds before meeting with an attorney?
It can be incredibly helpful. We'll definitely want to go through finances at that initial meeting. I always do tell people we can't give you a definitive answer until we see the financial records from the other party, as there may be assets you don't know about, things of that nature, but we'll be able to give you a good idea of with the assets you have and what you anticipate the other side having, what you can expect. Also, good to go ahead and get those financial documents gathered. They're required by the courts to be turned over to the other side, anyways, and the attorney will be able to get you the amount of documents you'll need, such as for your bank statements, you'll need 12 months, 24 months of credit card statements, 3 years of your tax returns, any property deeds that you've been on in the last 3 years, paperwork for trusts, partnerships, corporations you might be an owner of. But again, your attorney would be able to get with you on what exact documents they are. But having them available right off the bat, we can give you a good idea of what you should expect moving forward.
So, talking prior to filing, could counseling or mediation play a role before officially filing the divorce?
Yes, you going to mediation can be extremely beneficial. The two of you could come up with a postnuptial agreement at that time, or counseling to perhaps save the marriage. In fact, one of the questions that you'll be asked at final testimony when it is time to complete the divorce process is whether or not you believe counseling would be able to save the marriage. Um, Now, a general no will suffice, but if you tell the courts that we've already attempted counseling, that'll alleviate any questions the court might have as to whether or not that would be beneficial for you.
Now we've talked, mediation and potential counseling. What is collaborative divorce? We've heard a lot of stories on collaborative divorce as this new and upcoming type of divorce practice. Now, what is collaborative divorce?
So, collaborative divorce is the two of you will use an attorney. That attorney will um, get all of the financials together and they will put together what they believe would be the proper outcome for each of you. You should each have independent counsel outside of the attorney gathering those documents. And if you decide to end the collaborative law process, you would each have to find new attorneys from the ones you currently had. But it's essentially a way to give someone all of your documents, all of your information, and they just tell you, here's what our decision would be. Similar to an arbitrator, except that it's not binding. If you don't agree, you can say, forget this, you're all fired. I'm going to get a new attorney. We're going to go to court.
Okay, so now let's go forward. So we filed the case. Let's talk about finances. When a couple gets divorced in Florida, is it always straight 50-50 split of assets?
Not always. Florida does what's called equitable distribution. So 50-50 is the go-to, unless you can show that there's a reason one party shouldn't receive 50-50. And that generally comes up when there's been a dissipation of the assets through an extramarital affair, such as if you are seeing someone else and you're buying them, expensive jewelry or taking them on trips. That money will likely be considered dissipated, and the other party will receive funds equal to the amount you spent to offset before you would split the remaining assets.
What if one spouse handled all the finances and the other has no idea what assets exist? Could that person get taken advantage of in the Florida court system?
They could, but we have a lot of safeguards in place to dissuade you from doing that. First, you have to file a certificate of compliance in compliance with Florida Rule 12.285 for mandatory disclosures. That was what I spoke about when you were asking about coming in, the 12 months of bank statements, the 24 months of credit card statements, 3 years tax returns. It's an extensive list, but it'll cover any assets that you own, any property you might own, so that's all been disclosed to the other side. So even if you were unfamiliar with the finances, you'll be given those documents, or you should be given those documents, and the other party will have to sign a sworn affidavit that there are no other documents, that there's nothing else that's not accounted for in them. And if you do find out that they were hiding assets, Florida's removed the time frame on coming back after them for those assets. So it can be 20 years down the road, and you can say, I found out you had a house in another state that you didn't tell me about. I want my portion of it, and there's nothing stopping you time wise from going back and doing so.
So what about debt? If one spouse racked up a large credit card bill, does that mean the other spouse is responsible for paying it?
Generally, that will be split 50-50 for credit card debt. You would have to show that the credit card debt was racked up for non-marital purposes. And again, the easiest example of that is if you're racking up those credit card bills on an extramarital affair. Outside of that, most things are going to be marital, such as if you went out and bought all new furniture for the house without talking to your spouse about it. Well, that furniture is considered a marital asset. The debt to pay for it is a marital debt.
Well, speaking of marital, how does the court distinguish between what is marital and what's non-marital property?
So generally, we're looking at the date of the marriage as far as that goes. If you owned a house and you bought it before you got married, that's going to be non-marital property. If you had a debt before getting married, that's likely going to be non-marital debt. Now, you'll want to speak with an attorney, as there are ways to get a marital portion of a non-marital asset. However, that's a little more complex, and you'll definitely want to speak to an experienced attorney about those issues.
Now, does a prenuptial agreement override Florida's rules on equitable distribution?
It does. If there is a prenuptial or postnuptial agreement, and it breaks down how you are going to divide the assets and debts, then the courts will generally allow that to go through unless there was another reason that the contract would be invalid, such as fraud or duress.
So we talked about this a little earlier, if somebody could be taken advantage of, but what are the legal consequences if one spouse tries to hide assets?
Well, for one, you've committed perjury, and you would be throwing yourself before the court as far as what they would want to do in that regard, because you do have to sign um, an affidavit uh, under oath for both the financial affidavit and the certificate of compliance that you provided all supporting documents, and the financial affidavit lists all of the assets and debts.
So moving on from financials with regards to equitable distribution, I want to talk a little bit about alimony. The word alimony is stressful, and it can be stressful. Who typically has to pay for it, and how is the amount decided?
So many people think that only the female in the relationship can get alimony. That is not true. Alimony is available to both parties. You would just need to show that you have a need and the other party has the ability to pay. Um, Now, that doesn't go on forever. There are many different types of alimony, um, but generally, either party can pay, and you will need to show need and ability to pay from the other side.
So are there different types of alimony in Florida, or is it always like a monthly check for life?
No, there are several different types. In fact, Florida got rid of permanent alimony, so check for life is no longer on the table. Um, what we call now is durational alimony, and that will be it'll be a check for a certain duration of time, and that can be up to 60% of the length of the marriage, depending on if you are in a short, moderate, or long-term marriage. We also have lump sum. That's where the two of you agree you're going to make a larger payment, but will not be responsible for any ongoing payments. There's also bridge the gap, which is like it sounds, bridging the gap from being in a two income household to a one income household. That's capped at 2 years in length. And then we also have rehabilitative. This is generally for when one party was a stay at home parent during the marriage and now they'll be looking to go back to school. You'll need a rehabilitation plan with set amounts of money to be paid and a set deadline for you to get that rehabilitation done. But that way you can go back to school, increase your earning capacity. If you know, especially if you were earning zero during the marriage. But those are the four basic types of alimony for Florida.
Well, so let's talk about the length. We talked about duration. It can be for so long and the different types of alimony. What happens if the spouse receiving the alimony gets remarried? Does that automatically end the payments?
Generally, yes, remarriage of one of the spouses will terminate the alimony. But it doesn't even have to be remarriage, although remarriage will certainly cover the language that Florida uses, is a supportive relationship. So if you are cohabitating with a boyfriend or girlfriend, then that can count and terminate your alimony.
How does the length of a marriage influence whether alimony is awarded?
So the courts typically don't like to award alimony on short-term marriages. So if you were married generally less than 10 years, the courts aren't going to want to award alimony, although there are cases where they would do so. Once you get beyond that, you're in what's considered a moderate term marriage, and the courts are going to be looking at more the ability for alimony. But length of the marriage, which also factors into lifestyle you had during the marriage and the length that you have been accustomed to that lifestyle, the courts are going to factor in when determining if alimony is appropriate, and then if so, how much.
So, can prenuptial or postnuptial agreements affect alimony decisions?
Absolutely, they can. In fact, it's one of the main things that we look to take care of during a prenuptial or postnuptial agreement. It's one of the main things that people want in there is alimony, uh, that generally someone's looking for both parties to waive, and then we can add in an infidelity clause so that if one party is unfaithful, that affects whether or not they would have to pay alimony, and that supersedes Florida's no fault provisions in the divorce laws.
So moving on from alimony, and I want to talk about if a couple has children and there's children involved, how does Florida decide custody?
So Florida looks at the best interests of the child factors, which would include things such as domestic violence, geographic viability, willingness to foster a relationship with the other parent, the physical and moral fitness of the parents, keeping stability and routine for the child. Um, the courts are going to take those into consideration, having a rebuttable presumption currently of 50-50 for time sharing or custody.
So is joint custody generally the standard, or can one person still get sole custody?
So joint custody is the standard. Sole custody is not something the courts are really doing anymore. Even if one party is found to be a detriment to the child, they will still get some type of custody, even if that's only supervised. If the courts are giving no custody to one party and sole to the other, we're in an extreme case where they're likely looking to terminate the parental rights of the parent not receiving any time sharing.
So moving on, so we've talked about time sharing. Let's talk about child support. How is it calculated?
Child support is calculated in Florida using what we call the income shares model. So the court will take the total amount that both parties make per month and the number of children, and that tells the court how much support total will be needed for the children throughout a month. And then your child support amount is determined from there based on the amount of overnights you have with the child and what portion of the total income you are making. So if you are making significantly more money, even if you are found to be the custodial parent for time sharing, you may still owe money to the other side. I've seen it happen. It's very rare, um, but it can indeed happen in Florida.
Can parents waive child support in a prenup and or a postnup?
No, child support is considered a right of the child. Neither parent can waive on the child's behalf, even if that's by agreement. And that's whether it's in a prenup or postnup or during an actual divorce or custody case. Child support is going to be put in place, it's going to be calculated. You can deviate up to 5% from the child support number. If it is low enough, the courts could determine it what they call nominal and no child support be awarded. But when that happens, you'll generally need to be very close in income and having a 50-50 time sharing arrangement.
Another big concern we see is what happens if a parent moves out of state with the kids after divorce?
So, in order to move out of state with the children after a divorce, you'll need either the consent of the other parent or permission from the court. And that's whether you're moving out of state or anywhere up to 50 miles away as the crow flies, which is if it were in air, not necessarily by car. Um, and with that, you'll need to show that the relocation is going to be in the child's best interest. Again, this is if not by consent, if you're requesting it from the court. The courts will likely want to have a social investigator interview both parties and the child to make sure that the move will be in the child's best interest.
So I know we go into detail a lot in our previous episode that we did with specifically on child support and child custody issues. But one question I want to re-ask is, does a parent's work schedule or lifestyle play a big role in custody decisions?
It certainly can. While we do have the presumption of 50-50, one of the best interests of the child factors is whether or not you're going to need to use a third party. So if you are working overnights or your lifestyle just has you out overnight and that can be proven to the courts will want, instead of the child to be with a nanny, in-home caretaker, anything of that nature, they'll want the child to be with the other parent. So if your work schedule, you can't facilitate that, then likely the courts are going to allow the other parent to have that time. Also, other than overnights, if you can't facilitate getting the child to and from school due to your work schedule, that's another thing the courts are going to take into consideration when determining what is in the child's best interest for time sharing.
So, is there a certain age when the child's preference is taken into account?
There's no hard fast age. Generally, we're looking at 15 to 16. You're going to be fine for your preference to be taken into account. I've seen it as low as age 12. What the courts do is they'll take into account the maturity level of the child. And first off, you'll have to motion the court for the child to testify. At that point, the court is going to want to talk to the child and make sure that maturity level is there. And that will usually be done in private with just the judge, the child, and a court reporter present so that it can be recorded.
So, we all know that divorce is already a tough and financially and emotionally tough process. But from a legal standpoint, what's the biggest mistake people make during the process?
One of the biggest mistakes people make is wanting to win. Uh, Simply, what I tell people is win against the other outcomes. You don't need to win against the other parent. Don't, you know, don't cut off your nose to spite your face. Essentially, is I guess a saying that would go in line with that. Don't fight them over something that costs $5,000. That's going to cost you 15,000 in other expenses and fees. You know, make sure you're making decisions financially that are in your best interest, and when it comes to the children, that are in the children's best interest. Well, winning is not something that is black and white in these scenarios.
So, let's talk a little bit about social media. Can a thoughtless post actually hurt someone's court case?
It certainly can. Again, we have 50-50 now, so less so than before that, but especially if the child can see your social media posts, it's something the courts can consider when determining whether or not you're trying to foster a relationship between the child and the other parent. In a divorce, there are times where we've seen people posting pictures or making posts that they're selling items, and you can't sell or dissipate assets while the divorce process is going on. So social media posts can certainly come back to bite you if you are making them while you have an open case.
Now, have you seen situations where people seriously damage their own case by acting out of anger or frustration?
I certainly have. We've seen it many times where you'll act out of frustration. That might be a social media post, stating that you've done something or posting that you are with someone else. And then that can hurt your chances for alimony because the other side will now know you are in a supportive relationship. Or you may say something that will affect your time sharing with the parent if the court determines that works, that whatever you posted acts against the best interests of the child.
So, moving on to a slightly separate subject, but I think it's really just as important. What are some ways to keep conflict low, especially when kids are involved?
Trying to talk to the other parent before issues arise. Also, being flexible. Life's going to happen for both of you. There are times where if you have a schedule, it's going to need to be slightly adjusted. Times when You won't be able to have the time sharing when you're supposed to, times when you're going to be running late. Remember to extend that same grace to the other side. And when you do, they will generally do the same back.
So moving on, because I think this is really important that we educate our viewers and our listeners. How do you find the right divorce lawyer in Florida?
You're going to want to find a lawyer that matches what you feel the needs of your case will be. Some lawyers are much more aggressive, and if you feel you're going to have a highly combative case, then that may be something that you need. If you and your soon to be ex are still on good terms, you may want someone more pushing a mediation route or even a collaborative law route. Um, Having an attorney and yourself be in lockstep with what you're looking for and what you're wanting to do moving forward is crucial.
So what qualities should people be looking for specifically in an attorney for a divorce case?
So you're going to want them to have, first off, divorce experience. You know, you can go on the Florida Bar website, see what type of law practices, areas of practice each attorney does. You're going to want someone that does family law, possibly even that they do family law exclusively. As far as other qualities, someone that you feel comfortable with. You're going to need to tell this person the most intimate details of your life. It's not comfortable. Someone that you trust talking to can be critical to getting information to them that they will need to help your case later.
So is it ever beneficial to hire a local attorney who knows the court system in that jurisdiction or that locality?
It certainly is. All of our judges are fantastic here in Duval County. However, each of them handle cases separately. Um, we've had a recent case where someone had a settlement offer. And in assessing that offer, I told them what to expect, specifically because of the judge that they had. And that judge has a tendency to rule differently than our other local judges on a certain issue.
And lastly, is it ever wise to switch attorneys mid-case if you feel like you're not being represented properly?
It certainly can be. I always find it necessary that if you don't trust your attorney for whatever reason that's been broken, um, you need someone that you can trust, because when you're evaluating the information they're giving you, if you don't trust that what they're telling you is appropriate, then the advice they're giving you is not going to be helpful, and you're paying a good deal for that advice. Make sure you're putting it to good use. But generally, we don't recommend it, just because you're going to be paying for another attorney to catch themselves up to speed and then get moving in whatever direction they want to take your case, which may be different than the one that your prior attorney was going, due to something that you and your prior attorney had spoken about that you forgot to bring up to this new attorney.
Well, Josh, thank you for your time. We've covered a lot of ground today, from the basics of no-fault divorce and asset division to alimony, custody, and how to avoid the major pitfalls of divorce. For anyone thinking about filing for divorce, the most important step is getting informed, collecting financial records, consider mediation, and seek professional advice where you can. Thank you for tuning in to Law Unpacked. I'm Attorney Sean. If you found this episode helpful, don't forget to like, subscribe, and share it with someone who might need this information. If you have questions, drop them in the comments or send us a message. We'd love to hear from you. Until next time, take care, and remember that a little knowledge now can save you a lot of stress later. Take care, everybody.